in the discussion. Now we are supposed to watch the video that Rupert Podszun has delivered us. So Rupert has prepared a presentation about the German approach, how to regulate the data economy with national competition law. I would now let the video start. As you already know, Rupert Podszun is a professor of civil and competition law at the University of Düsseldorf. He is also a fellow at the Max Planck of Munich. Here is his video.
Buongiorno a tutti, grazie per l'invito a Margherita. I'm very sorry that I cannot be with you in Rome today. I would love to be, but now I have to give you my talk, my presentation in this video format. I was asked to talk about the German experience, the German cases and the proposals on how to regulate the data economy. And I put regulate in this sort of bloody, shivering font because obviously, that's a term that competition-minded people find problematic because regulation is not free market competition, but it is state-planned interventions. I think we are sort of on the scale of moving from one side to the other side, from free market competition, the free coordination of market actors, to a more regulated environment. And I find it very interesting to see what's happening at present and also to ask whether it's necessary to do so or not. Now, when I present the German experience to you, I have to make one point very clear. This will be stereotypical and cliche style because I can only give you this tiny bit, this tiny piece that I see as the German experience. If you present something abroad, you're always in that risk. But obviously, there are a couple of truths that we hold to be self-evident. The first is Germany always wins at football. German public transport is the most efficient in the world. And German car companies are a beacon, a shining light to the rest of Europe. So, with that having clarified, let me move to another shining light to the world, which is the Bundeskartellamt, the German Federal Competition Authority, which I think sees itself as a very pioneering, leading, shining competition authority, and it's craving for the 5 stars in the Global Competition Review Enforcement ranking every year, setting itself apart from the European Commission. And I think what we see here is really good competition. When the Bundeskartellamt found out that the European Commission has difficulties in dealing with the Google case, Google Shopping, 7 years of investigation, hefty fine, but very weak remedies. I think they saw that this is something maybe where we can step in. And Andreas Mund, the German president of the Bundeskartellamt, saw that this is a niche where competition with the powerful European Commission may be worthwhile. Just to give you an impression, the Bundeskartellamt in the years from 2005 to 2017 prohibited 36 major mergers, while a DG Comp only prohibited 8 in the same time. Okay, they have more notifications in Germany, but on the other hand, the big things, the really big things, are running in Brussels. So you may expect sort of there to have a stronger balance. So the Bundeskartellamt is a very proactive, is a very tough agency and likes to see itself as such as well. It entered the field of digital. And I want to make one thing very clear at the beginning. When talking about the German experience about how does Germany deal with competition law in this matter, I think that we have to be clear in one point. It is not a pure anti-GAFA thing that's happening here. Germany is not there to stop the GAFAs. There may be one line of thinking in the German experience where we say, yes, we need to control Google, Amazon, Facebook, Apple better than before. This is the stop GAFA line of thinking, sort of. And we have cases like that. But on the other hand, there's another important strand of thinking, particularly now with the legislature stepping in, which is we need to help Siemens. Take Siemens now as any German big industrial company. We need to enable German or European companies to enter the competition with companies like the GAFA companies. We have to keep them in the field. And this is also a part of competition policy in Germany, whether you like it or not. But this is another strand of thinking that you should not ignore and that we should be aware of, sort of. I just want to set that out at the starting point before I now turn to the cases, the line of cases that the Bundeskartellamt investigated. I show you a lot of cases now, and maybe this is more for you to read later if you get the slides or whatever. But I just want to show you particularly that it is not just one thing that the Bundeskartellamt did. Yes, the Facebook case is the most prominent case. Andreas Mund gave interviews in US television, which is something that most European heads of competition agencies really have to fight for and never achieve in a lifetime. He did it with Facebook sort of in a row. But the Facebook case is not everything. And you should also know one more thing. The German Competition Authority is organized like a court. There are decision divisions like chambers of judges of 3 that decide completely independently. This is completely different from the approach of the European Commission, where we have where we have the College of Commissioners and the Commissioner of Competition that can give a sort of hierarchical line saying we want to do it this way or that way. In the Bundeskartellamt, it's sort of a bottom-up approach where the decision division of 3 says, okay, we decide this case this way and that case that way. So it's always difficult to see a fully fledged strategy. Of course they communicate, of course Andreas Mund sort of puts in his weight, but he cannot force anyone to take a certain decision. So it's hard to say that there is one German experience. It's a variety and a richesse, and this is what I want to show you to the next slide. At the beginning of this were the MFN clauses, the most favored nations clauses that have been very famous or infamous throughout Europe, particularly with the booking, hotel booking portals, where the Bundeskartellamt started its investigation with HRS in 2013, prohibited the wider best price clauses, the clauses where hotels were prohibited to offer a lower price anywhere. They won that case in court, but they lost the next case, the Booking.com case in court, where they had focused on the narrow best price clauses, prohibiting the hotel to offer a lower price on the website. So the Bundeskartellamt lost with this case, and there is no additional regulation on that in Germany at present. So the MFN clauses were sort of the starting point in the Bundeskartellamt's dealing with these cases. There have also been cases where the Bundeskartellamt eased the way for the GAFA companies. In 2015, for instance, they dealt with Essex, the sports shoes companies, and told Essex, you may not force your retailers not to use Google, eBay, Amazon, and others. You need to grant them access to online marketplaces. You may not prohibit that in your selective distribution scheme. And they also sided with Google in an abuse case on whether Google abused the rights of the press publishers when putting the snippets on Google News. So there are decisions by the Bundeskartellamt stemming from 2015, for instance, where they were very pro e-commerce, very pro competition, and they acknowledged that these companies brought a lot of competitive power to the network. But this approach maybe changed a bit later on, and maybe things on markets actually also changed from 2015 to 2019. Merger control is always a very powerful tool, and it is particularly powerful because the companies cooperate with you and because you can develop concepts that you later use in abuse cases. This is actually what the Bundeskartellamt did in cases. You have the Parship and Allied Partner case, which is a case on dating platforms that had an aggregated market share of 50%. And although they had 50% of the market share in dating platforms, the Bundeskartellamt did not oppose the merger and said, there are no high barriers to market entry. There's always Tinder. You can use other dating platforms. There's multi-homing, etc. In this 2015 case, they developed the concepts that they later used in other cases on dominance, on abuses, on certain coordinated, non-coordinated effects. And for instance, in this case, what they had developed there, they played out in 2 years later with a ticketing platform, Eventim, which is very, very strong. If you want to go to a concert in Germany, you usually book your concert ticket via Eventim. And when Eventim tried to buy 4 artists, a booking agency, the Bundeskartellamt opposed the merger, and the merger was blocked. They won that case in court on the very concept developed 2 years earlier in a lighter case, sort of. By the way, Eventim is a German company. It's not a GAFA company. It's not a Silicon Valley company. This is a platform from Germany. So there's no, I think it's unfair to say that this has an anti-Silicon Valley bias. Then there are, of course, the abusive conditions cases. And again, here, Eventim is vital because in Eventim had an abuse case running on exclusionary conditions in their terms and conditions. And the Bundeskartellamt succeeded with this case, and they used this sort of case that did not gain very much attention worldwide to develop concepts that they later on explored in other cases. Then there are the two big 2019 cases, obviously, Facebook, exploitative abuse of user data, and Amazon Marketplace. And again, very interesting to see the different strategies. Facebook opposed the Bundeskartellamt's approach. The Bundeskartellamt took a formal decision. They now lost this formal decision in interim proceedings in the court. Different approach in Amazon Marketplace. Amazon cooperated very strongly with the Bundeskartellamt, changed its terms and conditions even globally for retailers on Amazon Marketplace, including the liability, the termination of contracts with retailers, etc. And the result on the markets was there. Whether that was a strong case or not, that's probably something that we can debate. But again, two very different outcomes, because in the one case you have the court having a say, in the other you didn't, because there was no formal decision ever adopted. Now, these are basically the cases that we think of when thinking of the digital cases. But I want to guide your attention to two other cases that, in my view, are incredibly important when we think about shaping the regulatory, the competitive framework for the data economy. And these two cases have not gained any attention on a larger scale. Partly because they are not even formal decisions in these cases, but they are very important on what they say. These two cases are cases dealing with the Internet of Things. The cases that we've looked at so far are very consumer-centered. They're dealing with products that we know, with Facebook, with Amazon, with ASICS sports shoes, with hotel booking platforms. This is consumer-centered cases. The two cases here are B2B cases. And I think that for the success of the European economy, for competition, the competitive framework in Europe, it's not so decisive what happens on the very sort of end consumer market, where US companies have always been very strong with their products. But it's very important what happens on the upstream market, basically, in the IoT cases, in the Internet of Things cases, in the B2B cases, where companies start to cooperate to profit from the data economy and platforms. Two cases on this. The one is XOM Metals, or XOM Materials as it is now called, from 2018. The company Klöckner, a German steel company, built a B2B platform that they wanted to roll out as a fully fledged sectoral platform for trading, data sharing and everything in the metal and materials business. And they closely cooperated with the Bundeskartellamt to frame it. So how much can we cooperate? How do we not enter into a position as an operator of the platform that is abusive? And the Bundeskartellamt gave a couple of pages guidance on this B2B case. No formal decision, but they said, okay, if you watch these conditions and that conditions, you may operate it like that. And this is sort of the blueprint for B2B platforms that are now being developed and that are now so very, very important for the industrial companies in Germany and Europe. The second case is the case of HERE. HERE is the former Nokia-owned navigation tool for cars. And it was bought in 2015 by three German car manufacturers, BMW, Daimler, and Audi. If BMW, Daimler, and Audi do something together, every competition lawyer should be like on alarm, on fire. In this case, the Bundeskartellamt said, you may. Here is the hub for automated driving, for connected driving. You need a lot of data, you need to feed the data into navigation, etc. And HERE is built sort of as the nucleus of automated driving by these companies. And the Bundeskartellamt, I think they hotly debated the case, can we allow these companies to enter into the market for automated driving together, building on a platform like HERE? But they only gave us one line saying, we do not oppose that case. We don't even know the case number. And 2 years later, two other heavyweights entered this business, namely Intel and Tencent. So two really, really powerful companies. And again, the Bundeskartellamt did not oppose. I think this shows the case that the Bundeskartellamt really tries to enable competition in the B2B business, fully exploiting the advantages that platforms and data prompt. So if I draw some conclusions from this line of cases, I would say the German practice is not just Facebook. Secondly, German decision chambers are independent. They pursue different strategies, and these strategies may have very different outcomes. Sometimes we don't even see a decision. Sometimes we see a decision. Sometimes they win in court. Sometimes they lose in court. So you may have very, very different approaches, and you should see this as the full picture of German experience. Thirdly, I think that you can recognize a certain shift in attitude from a more pro-e-commerce stance up to 2015, 2016, and later on changing into we have to control the GAFA companies better, and we have to open up the markets for the cooperation of German companies and European companies in the IoT field. I think there is a certain shift, and of course this is the shift that we had in the general debate in Europe over the time. Fourthly, one aspect that I find important and that may also explain the difficulties of the European Commission with the Google cases, you need the smaller cases that do not grab that much attention to develop the concepts that you can later apply in the larger cases that are really, really important. So if you do the CTS Eventim case, that's great. If you do the online dating portal case, that's great, because later on you can use exactly the concepts you have there on a case with Amazon, with the GAFA companies, with Facebook, where you have much more difficulties in putting your case through. Fifthly, ultimately, the success is determined by the courts. And this is a lesson that we are learning now with the Facebook case the hard way, in the sense that the courts need to follow the sort of new innovative theories of harm that the Bundeskartellamt comes up with. Now, I want to talk a minute about what happened in Facebook, just because this is the attention-grabbing case, and just want to make a couple of remarks on that. First thing is, if you want to understand the Facebook case, I think you always have to understand that this has a political angle. Before the Bundeskartellamt entered into the Facebook case and opened it in 2016, we had a discussion in Germany whether we should have a regulatory agency for digital markets. And the Bundeskartellamt instantly sensed, if we get a regulatory agency for digital markets as proposed by the Ministry of Economics in Germany, the Bundeskartellamt would lose a lot of influence and there would be hefty regulation in Germany for the internet. Instead, they said, we should show to the world we can do that, and maybe we get some more powers in consumer matters that the Bundeskartellamt does not have, other from the Autorität Garante, for instance. So I think the Facebook case was a showcase for showing, can we work with digital matters? It has this political angle, which takes it a bit out of the general process. Secondly, you also need to notice that the breach of data rules by the Irish Data Protection Agency was never investigated. There is no German data protection agency of any strength, and Germany does not enforce the unfair trading practices, the unfair commercial practices with any competent authority, with any public enforcement. We only have private enforcement in the field. So there was a sort of under-regulation in this field. Had others stepped in the field, the Bundeskartellamt would probably not have grabbed the case, but they probably argued in the sense that if no one does it, we have to step in. I think this is also one aspect of that case. The third aspect of the case that you should keep in mind is, this is, dear friends all over the world, this is a case on exploitation. And even in Article 102, the founding fathers of the European communities told us that exploitation of customers is a matter for competition law, buy it or not. I know that no one in the competition community likes cases on exploitation, but it's in the law. It is something where we are sort of bound by the law to act on. So the next question is, can you exploit users through conditions? The German law very clearly says, yes, you can. There can be a violation of competition laws if you exploit users through unfavorable conditions. It's not just excessive pricing, it can be excessive conditioning, sort of. The second problem is, if yes, what is the benchmark? So how do you determine that conditions are excessive? Prices, we know sort of with comparable markets, etc., we have a certain concept, but for conditions, we do not have such a concept, or we did not really have such a concept. And the Bundeskartellamt says we have precedent from the BGH, the German top court, top Supreme Civil Court, saying that the legal principles determining the protection of the negotiating party can be the benchmark for us to determine that there is excessive use of conditions. These are two very new and sort of very difficult decisions, VBR Gegenwert and Pechstein. But the Bundeskartellamt used these decisions saying, okay, if you accept that there are constitutional principles, that principles of imbalance that may sort of constitute exploitative conditions in abuse cases, we can use the principles of the GDPR, the Data Protection Regulation, and the constitutional rights to privacy as the benchmark for a violation of competition. So they took that from this, what they see as precedent. So I think these are just, I think you need to open your minds if you're very opposed to the Facebook case, if you don't understand it. I think it has a solid basis in German law and also I think in European law. Even if we are not used to these cases, the laws are there and we have to come up with concepts, and the Bundeskartellamt tries to come up with concepts because we haven't tried before. So this is different from the cases before where we had very clear-cut conditions like that. Now you know that the Düsseldorf court from my hometown has basically accepted that there may be dominance, but they quashed the case on several matters, and in particular they didn't see a causal link, and they didn't from dominance to exploitation, where they say this is really necessary in such cases, and they said there is no damage done to competition. So they didn't see the competitive link really. And I think this is the main criticism of the decision, that the Bundeskartellamt does not show that this really harms competition. You can now argue about this. Is that a requirement of the exploitative abuse cases that there is an additional sort of harm to competition? And how do you assess that? And this will probably be determined by the court who had set up these strange precedence cases in VBR Gegenwert and Pechstein. I think it's really open how this ends. I'm pretty sure that even the European Court of Justice will have a say in this with with preliminary proceedings. But we will see how it develops, and probably if it develops over time, it will be very late to come up with. The market power of Facebook is there. It's even harder and harder and harder to do something to put it aside again. So it will be very difficult to deal with that. Now, I wanted to give you just some short insight into what the legislator sees and what's the reaction of the German legislator. And this is very interesting because Germany seems to be the first country that wants to really pioneer with new legislation in the field. And this has a history. In 2017, we already amended the law with a transaction value-based merger threshold. This was the reaction to the Facebook WhatsApp case. So you have to notify your merger with the Bundeskartellamt if the price paid is more than 400 million euro. And also, they integrated into the law criteria for dominance of platforms and networks, like network effects, use of data, etc., etc. So that there have already been amendments in the German Act against the restraints of competition in 2017. Now, triggered by the ECN Plus directive, there will be a new amendment, and depending on how the German coalition government survives or does not survive, we will probably see this in the first half of 2020 as the 10th amendment of the Act. And in this case, in this act particularly, Germany wants to draft rules integrating these two strands of thinking: control GAFA, enable other companies to compete. The draft that we now see is based on studies like the Firmen report by Philip Marston, the Schweizer Haukapp-Kerber-Welker study on abusive practices in Germany, the German Commission Competition Law 4.0 report, the report of the special advisors and others. It is also based on the post-Siemens Alstom uproar, so integrating a bit of industrial policy. I think that it is in there. It's the same ministry that does that. If you want to read it, I cannot read out the clauses because it's really lengthy here and I cannot explain every detail. But if you want to see the English version of the draft, we published it in our blog, dcart.de, in a most important norms in an English version. And I also wrote an English summary with a colleague in the Competition Policy International, and you can find the everything in there. Just 3 highlights. Firstly, more on this, we need to enable companies to compete. The new act provides for improved access to data. So not granting access to data is now seen as an abusive conduct that you can go against. And this is very interesting because it had not been there. You see, data is now sort of defined as an essential facility, and even easier than that. So the threshold is easier to jump than for an essential facility. This is in section 19, para 2, number 4, and section 20, para 1a of the new Act, if you want to read it. Also, companies may be granted a comfort letter, something that we've known up to 2004 on the European level, if they want to cooperate. They get a comfort letter by the Bundeskartellamt. Of course, Bundeskartellamt cannot say anything on European law, but they aim at the Internet of Things situations so that you get some guidance for data pooling, etc. The second issue is Germany tried to put a provision into it against tipping. And this is section 20, para 3a of the new draft. And what they try to establish is saying, if you are a dominant company and you have rapid and you grow rapidly on markets, you may not impede other companies to attain the same network effects. I think this is sort of aimed at the Amazon exclusionary clauses style behavior, so that other platforms may sort of flourish even though your platform is already very strong. I think this is aimed against the tipping of markets. Very interesting provision, has not yet been discussed very much. The one provision that has been discussed very much, and I think that the Furman report is sort of partly responsible for that, is a special regulation of undertakings with paramount significance across markets. If you are a undertaking with paramount significance across markets, upscam is my abbreviation to that, you may now, the Bundeskartellamt may now say, you're an upscam, dear GAFAs. I think it's aimed at them. Dear GAFAs, you're an upscam. And now that we have established that, we can give you special duties and obligations and prohibitions. And these special prohibitions and duties and obligations are close to the P2B regulation that Inge and others are dealing with. So, for instance, you need to have data portability and interoperability. You need to ensure good information to the companies that are dealing on your platform, etc., etc. And this is very close to a competition-style regulation. You should read this norm. It's really sort of revolutionary. It's disruptive. We haven't seen that in competition law before. And we can even wonder whether it is competition law at all. It is in section 19a of the new draft. It's very long, so I don't want to put it on the slide here, but you can look it up in the blog. And here we start entering into a field where we have more like a competitive regulation of GAFA companies. What is not in the draft? No powers for the Bundeskartellamt in consumer law and no merger control that is specifically directed against killer acquisitions. We debated that, but we didn't find sort of a solution. Ladies and gentlemen, some conclusions very briefly. Firstly, I think that the Bundeskartellamt has not taken a one-dimensional anti-GAFA path. If you construe it like that, you're misconstruing the German experience. There's a large variety, a richesse of cases that you should take account of. Secondly, competition law reform tries to integrate the control of GAFA on the one hand and the industrial digital policy for European companies on the other hand. So the developments that we now see is really not one-sided against GAFA. It is controlling GAFA is an element in that, but the other strong element that we shouldn't sort of overlook with access to data, etc., is we try to strengthen the position of European companies in this competition. And that's part of the competitive framework, maybe if you wish so. Thirdly, the rules that are now new, and what we have also seen from the case practice, is that courts play the determinative role, the decisive role in this business. Even if you now grant data access to companies, and the legislator wants to grant that, it is up to the courts to determine the clauses, the conditions, and everything. So it very, very strongly depends on how willing the courts are to follow the Bundeskartellamt, or even in private enforcement, with these ideas. And I think that we have a certain time lag there with courts on the one hand and agencies on the others. Agencies very strongly avant-garde thinking, very strongly in the European debate and the international debate, and courts with a more traditional understanding, very, very focused on the legal issues, not on economic issues, not at all on digital issues. So I think we have a certain gap there, and the decisive question will be how this gap is filled by the courts. 3 final questions. Where do we draw the line of competition policy versus economic policy? Is it a breach of our competitive understanding if we try to enable European companies to join the competition? Is that industrial policy that we dislike? Or is that part of enabling a competitive process where we need companies to compete? Secondly, do the GAFAs merit regulatory style interventions? I think with Section 19A, we start into that path. And sometimes I think, well, what happens if Google is offline? What happens if the Amazon cloud is offline? Is that a systemic problem for our economies? If BMW goes offline, or if BMW does no longer build cars, no matter, we can all buy Alfa Romeos. But what if Google breaks down? What if Amazon breaks down? Would that be like the big crash? And if it would be the big crash, do we not need a bit more than just sitting back and trying to establish the very hard-fought 102 cases? And finally, how do we innovate on the EU level? On the German level, we have seen a lot of cases, many more cases than on the European level. We have a legislature that is active and that pursues an active path. And we have courts that now may follow suit or may not follow suit, but that's sort of the imbalance. On an EU level, we have the European Commission only taking the big cases and running into risks with that. We have a legislator where I hope they do not even touch on Article 101 and 102, because the outcome may be disastrous if I think of what politicians there have on their minds. So, and then we have the European courts, where with the same insecurity that I sense with the German courts. So how shall we move forward on that level if we think that we need some action there? Can we all rely on Margrethe Vestager's powers if we do that, or are we sort of caught in a situation where it's very hard to escape? I have no definite answer to that, but I'm happy to discuss, and thank you very much